Hello and welcome to yet another episode of the In-Depth series. My name is Pooja Dwivedi. Today we are going to discuss the right to be forgotten. It is in the news again, and that is why it is important to discuss all these important information related to it. So first of all, we have to know what is the right to be forgotten. It does not mean that people should forget you. It is in fact the right to have one's personal information which is available for public access, such as on the search engines and online directories on certain grounds, to be removed once it is no longer needed. And individuals may seek to have their information, including videos, photographs, and identifying info, to be deleted. Again, once not needed. Okay, so this is right to be forgotten. If we have to discuss what is right to be forgotten, do you know that it forms a part of the right to privacy and the right to privacy? In the Justice case Puttaswamy versus Union of India case of 2017, the apex court suggested and declared that right to privacy is a fundamental right under Article 21 itself, and that forms the part 3rd of our constitution. It is an intrinsic part to the right to life and personal liberty under Article 21, because if I have to live my life happily, I might keep some things private. And right to be forgotten is a part of right to privacy only, and under Article 21 it is. It's an umbrella term. Now, and this forms as a part of the freedoms which have been guaranteed under part 3rd of the Constitution against the state. Now, right to be forgotten is the deletion of certain information which is no longer needed to be deleted from the public accessibility. And this can include search engine, database, website, or any other public platform. And that is to be done once the personal information is no longer needed. Sometimes it is relevant from the perspective, supposedly I am a person who wants to fight an election. My personal details are important for the other person to make certain decision under Article 19, right to freedom of expression, So if a person does not know much about me, how can they express their vote in my favor or against? And the right to be forgotten gained importance after the 2014 decision of the Court of Justice of the European Union in the Google Spain case. Remember this, okay? Now, right to be left alone is also something. That does not mean that a person has the right to withdraw or isolate from the society. It means an expectation that the society will not intervene into the personal matters of the, of citizens of India. So this is what it is. Now, of course, that also has, certain conditions that the conduct of the person should not be harmful. I cannot say that, okay, I will murder this person and I have murdered that person and I have the right to be left alone. Not like that. Okay. Now, the debate surrounding, we have to ensure that we know the for as well as the against of the right to be forgotten. There are always pros and cons. So remember that. For those who are in favor of the right to be forgotten, they say that it is necessary due to issues such as revenge porn uploads. Sometimes it can happen that people engage into intercourse activities, and they document it. And if those persons are no longer related to each other, no longer interested in each other, revenge porns might take place. Now, to ensure references to petty crimes individuals may have committed in the past don't haunt them. Supposedly, a person might have committed the crime, they might have gone through rigorous punishment. Even after that, they tend to be stigmatized because of the availability of certain information against them. The person might have changed, but the past is continuously haunting them. That is also another thing. Potentially undue influence that such results exert upon a person's reputation if not removed. It will also harm a person's reputation, which is against the right to life and liberty under Article 21. Those who are not in favor of right to be forgotten, they say, questions about the practicality in attempting to implement such a right. Where do we draw a line in which we can decide this particular information is important to be remembered and this is important to be forgotten? What is the line? What is the objectivity in this subjectivity? Concerns there are about the impact on the right to freedom of expression. Again, the same example, I want to fight an election, the same example fits here. I want to exercise my right under right to be forgotten, but the other person might want to exercise their right under Article 19, right to freedom of expression, because they want to elect me or not elect me. Concerns that it would decrease the quality of internet because too much censorship is happening. That is also another problem. Moving on. Now, if we talk about the issues associated with right to be forgotten, first is privacy versus information. How to balance Article 21, right to life and liberty, and Article 19, right to, freedom of expression. And it is the balancing with the other conflicting rights. This is the problem. How do we know where do we have to draw the line? The apex court must do something here. Enforceability against private individual, because the right to be forgotten will normally be claimed against a private party, a media or a news website. What is the collective? Generally what happens, that the rights are available against the state, the fundamental rights. Now this right can be made available against the citizens as well. How to know that? Okay, so this is also another issue. There is also ambiguous judgments related to it, because in recent times, without a data protection law, which was suggested by the Justice B.N.C. Sri Krishna Committee in 2018, to have a data protection bill, it is not yet enforceable. So where do we draw a line? There is a lot of issues. Certain courts have accepted that there should be right to be forgotten. Certain have not been accepting that. So there is this problem as well. Now, government has taken certain initiatives in order to preserve the right to be forgotten. First is Personal Data Protection Bill 2019, and one that has been revised as well. So it provides for the protection of privacy of individuals which relates to their personal data, to establish Data Protection Authority of India to enforce the same. Now this was, propounded based on the, report of the Justice B.N. Sri Krishna Committee. It has not yet taken place. That means it is just a bill, not a law. Second one is Information Technology Act 2000. It does not deal explicitly with RTBF but implicitly. It provides for safeguard against certain breaches in relation to data from the computer system. And it contains provisions to prevent unauthorized use of computer devices and data stored therein. So it does not explicitly does it, but implicitly. But what do we need to do? We need the Parliament as well as the Supreme Court to do something, as in, first bring out a law with respect to personal data protection. Supreme Court should ensure that the two conflicting articles, Article 21 and Article 19, what is the line to be drawn? On what is the criteria on which one decides that there is a right to be forgotten for this person and not for the other one? So a judgment, a landmark judgment as well as a law would help. That's it. Thank you so much for watching.